No, I'm glad it's getting out. I figured.
Welcome to the Zoning Board of Appeals meeting. It's August 9th. And we only have one applicant tonight, Kearsarge Energy. It's, we are here to hear an application of a denial to construct and operate a solar energy storage facility on the Norfolk Aggie School campus due to the determination of the building inspector. So, do we want to start with Kearsarge? Please?
Thank you, Madam Chairman. For the record, my name's Dan Bailey. I'm a land use attorney from Pierce Atwood in Boston. I'm representing Kearsarge in this matter. With me here tonight are Andrew Bernstein, who's the managing partner at Kearsarge, Bethany Bartlett, the general counsel, and we also have Scott Lopez, who is the attorney for Norfolk County, who was unable to make it last time, but will speak to this project tonight. I'm not going to talk long. I talked a lot the last time, so I want to just briefly respond to comments that were raised at the last hearing. And Scott will speak to the county concerns and why the proposed project is an essential government function, not subject to the Walpole zoning bylaw. And the team is prepared to answer any questions that the board may have. I submitted a letter on August 6th. I'm sure the board has it, and that was meant to get in and respond to issues and comments raised at the last hearing. Like I said, I'm not going to talk about that in a lot of detail. You've got that. It's fairly lengthy. But there are 2 or 3 items I'd like to emphasize. We firmly believe this project is exempt from zoning for 3 reasons. The first reason is it's an exempt educational use. Our letter includes a considerable amount of detail about how the request for qualifications that was put out by the county and the agricultural school required Kearsarge to, at a minimum, include the North Street solar array as part of its proposal. We have included key pages from the RFQ and highlighted those sections that speak to educational use. There's a section on the second page of Exhibit B that I've highlighted, and I'm just going to read it quickly. It says specifically, the purpose of this RFQ is to elicit qualifications under 225 CMR 19 from respondents who will design, procure, install, test, commission, own, operate, maintain, and decommission a solar photovoltaic power generating system, the PV system, with guaranteed on-site electricity generation at 1 or more of the sites identified in this RFQ, and to develop a 9th through 12th grade curriculum in solar energy that conforms to Common Core and next generation state science standards. There's also a letter in the file that came in, I think, earlier this week. Maybe it was today, maybe it was last week, from the agricultural school itself. That letter talks about how the school has been been engaged in the solar project since its inception in 2017. Initially with the creation of the Norfolk County request for qualifications for solar energy services, which focused on development of a solar project at the county-owned North Street property. The Aggie initiated the request for solar, which was developed in cooperation with the county and Aggie administration, as well as the teachers and students. And that's a letter from the principal of the agricultural school that you have. The second reason that we believe the project is exempt is because the Massachusetts Zoning Act states that municipalities cannot prohibit or unreasonably regulate the installation of solar facilities except when necessary to protect public health, safety, or welfare. The Walpole bylaw, which limits ground-mounted solar arrays to a very small part of the town, is in our view overreaching and non-enforceable. It does not require any finding of a detrimental effect on health, safety, or welfare, and in this particular case, such a finding cannot be made. The third reason that we believe the project is exempt is because it performs an essential government function, and Attorney Lopez is going to speak to that in a minute. I just have 2 other things that I'd like to mention. The first is, this is, and I know you know this, but I'm going to reiterate it. This is a little bit different hearing than a zoning board or planning board typically has. Your job is to really be like a judge and interpret and apply the law. It's very different than when you're in a permit granting situation where you're balancing impacts versus detriments. And for that reason, while there are a lot of concerns and very good concerns expressed about this project, we understand that. Those concerns, aesthetic concerns, things like that, are really not relevant because you're not in a permit granting situation. You're much more in a position where you are obligated as a board to enforce the Massachusetts Zoning Act. And in this case, we believe very strongly that the Massachusetts Zoning Act requires that you overturn the decision of the building inspector. Also, we've said this before, I just want to say it one last time. All you have to do is find that one of the exemptions apply. If any one of the exemptions apply, then your obligation is to overturn the building inspector. Thank you, and I'd like to turn it over to Attorney Lopez.
Okay, thank you.
I'm glad he told us.
Madam Chairwoman, members of the board, I want to begin by thanking you for the opportunity to speak to you today. My name is Scott Lopez. I'm with the law firm of Lawson and Whiteson. I represent the county in this matter. I've been representing the county since 1991, or for nearly 30 years. This evening, I will explain to you the county's view that the building inspector's denial of the Kearsarge permit application was wrong. First, I want to give you some background on how and why this whole process started. Second, I want to explain why the essential governmental function doctrine permits Kearsarge to move forward. And lastly, I want to explain the county's unbending commitment to fighting climate change with clean energy on behalf of the 28 cities and towns that make up Norfolk County. First, how and why did this whole process start? In February of 2016, the county learned that the Norfolk County Agricultural School was interested in bringing solar to the school and to the classroom. In April 2016, Governor Charlie Baker signed an act entitled An Act Relative to Solar Energy, which was to continue the expansion of the Commonwealth's solar industry and establish a long-term framework for sustainable solar development in our state. Shortly thereafter, the county commissioners authorized me to begin drafting a request for qualifications, which you've seen, for an energy management services agreement. Now, to understand the county commissioner's decision, one must understand how the Aggie School is financed by the state and the county, and how the financing of the school ties into the essential governmental functions of the county, including the county's commitment to clean energy. The Educational Reform Act of 1993 radically changed the funding of public education across the Commonwealth. The act eliminated the primary dependence on local tax revenues and established in its place a foundation budget for each and every Massachusetts school district. Those familiar with the funding of the Walpole schools know that each municipality must provide a standardized contribution to education. Like municipalities, the Aggie School has a foundation budget established by the state that the county contributes. Now, in recent years, the county has struggled with the fact that the school's costs, including utility costs, employee health insurance, and special education needs, have grown faster than the annual revenue increases. I'll come back to the utility costs in a minute. Now, because the county has always made Aggie School funding a priority, and because the county has historically exceeded the county's mandated contribution to the Aggie School and considers the Aggie School the jewel of Norfolk County, the county needed to identify other sources of revenue to keep pace with the school's rising costs. At the same time, consistent with the Commonwealth's energy policies, the county was looking for ways to reduce the county's carbon footprint by transitioning to clean solar energy. Now, faced with these fiscal challenges and the county's commitment to clean energy, in June 2019, the county issued a request for qualifications for qualified renewable energy contractors interested in implementing a performance-based renewable energy system with guaranteed on-site electricity generation on certain county properties. The county's intent was to use the project to address several important governmental functions. Specifically, the stated reasons for issuing the RFQ included reducing energy utility costs, promoting and supporting the development of renewable energy resources, reducing the county's carbon footprint, and developing a 9th through 12th grade curriculum in solar energy for the Aggie School that conform to Common Core and next generation state science standards. In addition to the fiscal benefits from the project, the county's intent from the outset was to provide Aggie students with a science-based curriculum that concentrated on solar energy and its vital role in sustainable farming in the future. Because the project was expected to increase revenues, the project was also linked to the county's other essential governmental functions. These essential functions included promoting the development of renewable energy, reducing the county's carbon footprint, and managing the county's business affairs. In July 2017, the county received 2 responses to its RFQ from 2 very qualified companies, and in September 2017, almost 4 years ago, the county selected Kearsarge Energy for the project. Now, in August 2017, the county also reached out to the town of Walpole, requesting its support for a proposed amendment to the town's large-scale ground-mounted solar photovoltaic overlay district as a warrant article for the town meeting in the fall. The county's purpose was to be a good neighbor to Walpole and its citizens in the planning for this essential project. In early October, the county appeared before the town's planning board at a public hearing in an attempt to garner the support of the planning board and the citizens of Walpole in advance of the fall town meeting. However, because some citizens distributed propaganda to the Walpole community, the planning board did not move forward. I'd like to submit for the record the propaganda that was submitted to the planning board and was distributed to citizens at that
Okay,
meeting.
thank you.
And I will note that propaganda doesn't in any way reflect what the project that we're considering here today. I brought a copy. Now, when the planning board would not support the proposed warrant article, the county withdrew its request to add the warrant article to the town's fall meeting. Notwithstanding the board's lack of support, the county was determined to fight climate change with solar energy. So in early 2018, the county reached out to Walpole's Board of Selectmen, and at that time, the attorney representing the town asked me to give her a written opinion on the county's position that it is immune from the town of Walpole's zoning regulations under the essential government function doctrine for the proposed solar installation. In April 2018, I sent town council a 12-page opinion letter setting forth the county's position. To this date, the town has not refuted that opinion in writing. Now, let me stop here to point out that no credible argument can be made that climate change is not a reality. In fact, the news today out of the UN, front page news of the Globe. So it's even more true today than it was in 2017. Similarly, there's no doubt that public school education in Massachusetts is an essential government function. This right is written into the Massachusetts Constitution. There can be no doubt that reducing the county's carbon footprint is an essential governmental function. That is why the Commonwealth has an Executive Office of Energy and Environmental Affairs. That is why the Commonwealth has published a roadmap to achieving net zero emissions by 2050. That is why most recently in March 2020, the Baker administration signed into law an act creating a next generation roadmap for Massachusetts climate policy. This legislation commits Massachusetts to achieve net zero emissions by 2050 and authorizes the Secretary of Energy and Environmental Affairs to establish emission limits of no less than 50% by 2030 and no less than 75% by 2040. This legislation is why our Commonwealth leads the nation in its effort to combat climate change. Thus, there's no plausible argument to the contrary that combating climate change is an essential government function. In fact, it's my understanding that as of April of this year, April 7, 2021, Walpole became a green community. Now, turning now to the essential government function. As some of you know, the law in Massachusetts is that a county is immune from municipal zoning unless a statute states otherwise. The doctrine of essential governmental function prohibits the town from regulating the county in a manner that interferes with the county's legislative purposes unless a state statute says otherwise. The scope of the county's immunity is broad and applies not only to property and facilities it owns, but also to property it leases and property it leases to private parties. The essential governmental function doctrine does not provide absolute immunity from all local regulation. For example, regulations that protect health, safety, or public welfare can be applied to a county project. However, the doctrine does provide immunity from any zoning regulation, including the rural residential district zone, in this case, that interferes with the county's essential governmental purposes and has more than a negligible effect on county operations. Now, there can be no dispute that the county is an instrumentality of the state. There can be no dispute that the Aggie School is organized by the state as a state-aided, independent public vocational school. There is no dispute that the land, structures, and improvement that make up the school's campus are owned by the county. As stated above, public education is beyond question an essential governmental function. And what the county seeks to accomplish with this project is clearly within the scope of the essential governmental function doctrine. The county, through its county commissioners, is mandated by law to provide essential government functions including the care of county property, the management of the county's business affairs, the sale or lease of county property, the preparation of county budgets, the taxation of cities and towns, and the funding of public school education at the Aggie School. All of these activities are quintessential governmental functions. Together, they are the reason for county government. More importantly, there's no state law that gives the town of Walpole any veto power over the county's management of these essential governmental functions. Also, the law is clear in Massachusetts that the essential governmental function doctrine is broad and applies not only to properties and facilities owned by the county, but also to property and facilities leased by the county or to others. In addition, the doctrine extends beyond the essential government function itself at issue to cover any action reasonably related to that function. Thus, the county's public mission cannot be prevented by a local zoning ordinance. And it does not matter that the county will lease some of its property to Kearsarge, a private party, to generate solar power for the county when the project is directly and inextricably linked to the county's governmental functions. In fact, Mass General Laws, Chapter 34, Section 14, specifically permits the county to lease county land. Permitting Kearsarge to build and maintain a solar array will allow the county to achieve its goals of fighting climate change, carbon footprint, etc. And it doesn't matter that the county will not be using all of the energy generated by the solar array, but for the fact that we have energy with suppliers other than Eversource, we would be using all of it. First, the county and the school will be using more than half of the energy produced by the array. Second, the North Street array is linked to the solar panels and canopy at the school's campus and the school's use of the North Street property, because the school uses the North Street property for farming purposes. The North Street project and the solar panels at the school have, from the very beginning of this process, been one project. Indeed, the RFQ that started this process stated that the minimum scope of the project is a ground-mounted PV installation on the county's land located at North Street. The North Street solar array was and is the primary purpose for the RFQ. Also, the canopy at the school was installed by Kearsarge in reliance on the application of the essential governmental function doctrine, as declared by your building inspector in an email dated October 20th, 2020, wherein Mr. Yanovich stated, and I quote, "Moving forward, so everyone is on the same page, the zoning exemption will come under essential government function and not the Dover Amendment," unquote. The building inspector denied the permit because the county's property lies in the town's rural residential district, and the proposed project is a large-scale ground-mounted solar PV system. Thus, the building inspector decided to apply the town's zoning bylaws to effectively prohibit the project from moving forward. This is exactly what the essential governmental function prohibits. The building inspector doesn't have a veto power over the county's essential governmental functions. It's obvious that the building inspector's decision is wrong. Indeed, if the building inspector's denial is not reversed by this board will be violating the well-settled law in the Commonwealth. The board should also know that if you uphold the building inspector's denial, you'll also be violating Section 3 of Chapter 40A, which is entitled Subjects which zoning may not regulate, and states that municipalities are prohibited from adopting zoning bylaws that prohibit or unreasonably regulate the installation of solar facilities except where necessary to protect the public health, safety, or welfare. To my knowledge, there's been no credible information that the project at North Street will have any adverse effects on the health, safety, or welfare of the citizens of Walpole. Indeed, quite the contrary. The project is beneficial to the public because it furthers the Commonwealth and the county's policy goals supporting renewable energy. And lastly, I want to explain to you the county's commitment to the 28 cities and towns that make up Norfolk County. The county firmly believes that reducing energy costs, promoting renewable energy resources, reducing the county's carbon footprint, and developing a 9th through 12th grade curriculum in solar energy are in the best interest of the county and its citizens. For the last 4 years, the county has spent valuable and limited resources to accomplish these goals for all of Norfolk County. The county remains committed to working with the town of Walpole to make this project work for the county and for Walpole. However, the county will not allow a small yet vocal minority claiming to be environmentalists and motivated by their own self-interest to prevent the county from combating climate change, reducing the county's carbon footprint, reducing the county and schools' energy costs, and educating Aggie students. Let me repeat that. The county will not allow a small yet vocal minority claiming to be environmentalists and motivated by their own self-interest to prevent the county from combating climate change. Going forward, the county will continue to pursue these laudable policy goals on behalf of all the citizens of Norfolk County, and will take whatever steps are necessary to accomplish these goals. It is the county's sincere hope that this board and the town of Walpole will join us in supporting these policy goals on behalf of all the citizens of Norfolk County. Climate change is real, and the time to fight is running out. It is not our duty to finish the work, but neither are we at liberty to neglect it. In closing, the county respectfully requests this board to vote to reverse the building inspector's erroneous decision and permit this essential project to move forward. For the record, I'd like to submit my remarks in writing.
Thank you.
Thank you.
Great, thanks. You guys want to do questions now or wait? Whatever you choose. Go for it. Can we do questions from the board now, if that's okay?
Thank you for that presentation. I had just a couple of questions regarding the, I guess we can start with the essential government function piece. I'm curious if the county owns or operates any other power plants within the county?
We do not.
Okay. And you mentioned that there's a number of state-level agencies, such as DOER and others, have as part of their mission to combat climate change and develop renewable energy. Are there divisions or departments within the county that have that as their mission as well?
Well, before we were able to publish the request for qualification, we actually had to have DOER review it and approve it. So it would be their standards.
Okay. And you mentioned that the essential government function extends to property that is leased by the county or other government agencies. As I understand it, that covers situations where the county itself is the tenant in a building and is doing its government function in that building as a result of that lease, as opposed to a situation where, let's say, the Aggie school itself was to be decommissioned as a school and converted to, let's say, apartment buildings. That even though that took place on county property because it was developed by a private party for apartment use, that use is still subject to zoning. Isn't that correct?
The issue is whether or not
To the microphone, please.
Thank you.
the county doesn't have to own the facility in order for the essential governmental function to apply. The case law is clear that in cases, for example, where the MBTA has raised revenues by commercial advertising, that the zoning laws don't apply to interfere with them being able to raise that additional revenue, because that revenue is a source of funding for the MBTA to pursue its mission of providing us services in transportation. It doesn't matter whether it's a private contractor. There's case law, the Bourne case, in fact, which is where excuse me for a second. The Nantucket Steamship Authority leased out private property in order to have overflow parking, and the town of Bourne attempted to prevent the private party from providing parking because it was prohibited by the local zoning. The SJC decided, no, you can't do that because that's interfering with Nantucket. So the way to look at this is, if the county had the resources to build their own solar energy facility, they could do that on this property and the town couldn't stop it. By extension of the essential governmental function doctrine, leasing it to Kearsarge to develop it and pay the development costs, and then paying us rent and also giving us reduced discounted energy, is another way for the county to achieve net neutrality.
Thanks. And one other question. You mentioned that there were, I believe, 4 factors you mentioned regarding the RFQ. One was to reduce the carbon footprint. Another was to assist with the costs of the utility costs, essentially, and generally the fiscal affairs of the county. And then the 4th one was the curriculum that was referenced. It strikes me that the predominant purpose of those, there's 3 of the 4 deal with essentially revenue generation. And you mentioned that at some length in your remarks. And it strikes me that the predominant purpose of the RFQ is to raise revenue for the various reasons you mentioned, as well as perhaps the goal of reducing the county's carbon footprint. And I'm curious as to the curriculum, if that part of the contract, I think it mentions 9th to 12th grade curriculum being submitted by Kearsarge. Has that been submitted to the county at this point, that curriculum?
I'm not sure of the answer. I don't want to misstate anything. I do know that the school already has, I think, 7 or 8 curricula.
Yeah, we have
that deal with
in
that.
the,
But I would respectfully disagree that the main purpose of this was to raise revenue. The revenue was certainly a part of this, but it was really moving to solar energy, which was the impetus for this. And yes, there's the benefits of clean energy and the carbon emission reduction far exceed the amount of money that the county's going to receive from this project.
Okay, thank you. Those are all my questions on that topic. I had a couple on the, let's see. I guess I don't know if Mr. Bailey or anybody else can answer the question about whether the 9th to 12th grade curriculum that meets the Common Core standards has been developed by Kearsarge and submitted to the school.
Hi, Andrew Bernstein from Kearsarge. We've given elements, we've had discussions, but as part of this project, once we start the project, we have to build the curriculum because the school will be involved in the design, will be involved in all the different elements and also in the operation maintenance. We've already delivered some elements to the school in terms of a whole reporting system. So it's a process. But as of right now, they have access and we'll see how there's a dashboard of how the data can then be used and downloaded and used as part of their curriculum. And we've also had discussions with numerous teachers on what's the design and the different pieces, including one teacher, Peter Kane, whose his courses are on sustainability. And so he's already had access to some of this. He's the one who even taught a summer course this summer focused on renewable energy.
The reason I ask is one of the attachments in the most recent letter included part of the RFQ. And in it says that within 120 days of the award of the contract that the curriculum is to be delivered. And I take it from what was described earlier that the contract was awarded in 2017, I believe. So I'm just trying to understand, it sounds like that component of the RFQ was to be satisfied, or once the award was granted, that the awardee, so to speak, should be putting forward that curriculum within 120 days of the award.
Right, but the date of the award was also when we signed the contract. So the contract, what Mr. Lopez referred to, the Energy Managed Services Act, was just signed
January 15th.
in January of this year. So that's the period. However, we had delivered some different elements as part of it, and that was through the whole reporting system. But until we signed the contract, so then we worked on it from that.
Okay. Great, that's the only question I have.
Let me add that. We selected in September of 2017, Kearsarge to negotiate the contract. Because of all of the issues involved in this project, it took a long time to actually get to the contract signing. And since that time, there's also been a lawsuit filed by the Walpole Preservation seeking an injunction. And so Kearsarge has been a committed partner and has committed tremendous resources out of pocket towards this project without any guarantee that this project was going to move forward. But they have delivered as best they could under very trying circumstances.
Thank you.
Anybody else down here? I have one myself. You said that half the energy from this project is going right back to the school?
Back to the school and the county, 56%. So,
How much is going to the school?
I don't have the exact figures, but the point, I guess, Madam Chairwoman, the county and the school is one and the same when it comes to energy, because the budget of the school is, although passed by the trustees of the Aggie School, the county is the one that primarily funds that. So whether the money goes to the county and then directly and then indirectly goes to the school, or whether it goes directly to the school, as in the case of some of the solar panels on the campus itself, the school's going to benefit from discounted energy.
So there's no real calculation
Well, there is, but it's a very complex calculation. I mean, I can submit something in writing to you after the fact, but it depends on where it's located, depends on the kilowatts, it depends on, it's in the contract. We have certain earmarks for the amount of energy, but it's actually a work in progress at this point in time.
The way renewable energy works is it's not necessarily they're seeing the energy, they're seeing the credits, the way the program's been set up in Massachusetts. So they're seeing a portion of the credits because some of the energy will be used to offset, but from a financial perspective, it makes more sense the way the program was set up in Massachusetts. And the way it works with utilities is they get what are called under the new program, which has changed, called the SMART program. They're getting alternative on-bill credits from this project. So they'll get basically $1 credit that gets on your energy bill. That's just the way the program works.
Did the school apply to do any other solar panels on the school? Like to do its own buildings, not just the parking lot?
Yes, there are solar panels on some of the buildings. Some of the buildings will have solar panels eventually.
Do they have them now?
They have them now, yes.
How many?
Four buildings have solar panels right now. We had challenges, and this was one of the reasons why I started with North Street, is a lot of the roofs on these buildings are quite old and are not capable of having solar panels on them.
There's also a canopy that's on.
I know, yeah, yep. Okay, thank you. You have
So-
anything?
Yeah, yes, I'd like to make a comment here. I feel these bully tactics, suggesting that the citizens of Walpole are pretending to be environmentalists. While I do commend the work of the lawyers on this issue, and I really do, was well represented, I find it very offensive to make veiled threats in attempt to intimidate the board to vote favorably. It's also offensive to tell the board what our role is and suggest that we are obliged to vote favorably on this without any choice. Understand that we're volunteer members for the town on this zoning board, and we take very seriously any and all articles that come before us, and vote on the data as we feel appropriate. Yeah, that's fine.
The county means no disrespect.
Sorry.
But these so-called environmentalists who are supposedly conserving the open space are, by blocking this, damaging the environment as a result of climate change. If
I was-
climate change continues, the current agricultural production of this country is going to go in the toilet. So we all have to have an active role in reversing the effects of climate change.
I
And this is
understand
just
that,
one
but
small part.
I understand that, sir, but you are belittling those citizens who really are environmentalists. You're lumping them all in one group, and I find it offensive, quite frankly. You've done a wonderful job, the lawyers, on your presentation, but let me tell you, this to me is bully tactics, and I'm sorry.
Well,
We're not to be bullied. We'll make the best decision we can.
And they filed a lawsuit against us to stop this project, so we're not the bullies when it
It
comes to
wasn't the
this
town that
project.
filed it, individual people. That's
But
not
it's
the
It's
town.
the same citizens you're referring to.
You all set? Anybody? Anybody else from the Kearsarge Aggie side? Would you like to speak?
If Kearsarge, the county are done.
Go for it.
Madam Chair, members of the board, Mike Yanovich, Building Commissioner. This podium I can get behind a little bit better, seeing it's in this position here. Just a couple of things. So one, I'll just reiterate, the building department is not anti-green energy. Our record shows that we're not anti-county and our record shows it. I give the county money out of my paycheck every week, and they handle my retirement, so I'm trying not to ruffle any feathers here tonight. But with that said, you know, we have a duty to protect the citizens of Walpole, and the zoning bylaw is in effect, one, to allow citizens or businesses to utilize their property in a manner that they wish that fits the zoning bylaw, but two, it also is there to protect abutters and other citizens. It's a quality of life document, essentially, is what it is. And I believe we're acting in good faith in doing that. I'll reiterate what I said the first hearing is, I don't believe any of these statutes or 40A or you know, essential government function are absolute. It's all fact-based. It's all case-based. It's circumstantial, based on what is in front of you. Thank you for thank you for the moving parties council for jogging my memory. I did misspeak last hearing in saying that we issued the permit for the canopy at the school based on the Dover Amendment. I did review the 161 emails that I have pertinent to this project, and did come up with, I asked, based on the canopy at the school, I asked counsel for the county, Mr. Lopez, to provide me with an opinion as to why we should issue the canopy project as of right. And if you allow me, I'll just read a little excerpt from that response, which includes my request. So my request was, it's not clear from the letter why leasing county property for the installation and operation of this particular private solar installation is reasonably related to that essential government function. If the majority of the power produced by the facility will serve the Aggie school or other county uses or provide credits roughly equivalent to the county's use, the letter should be specific to that point. If the majority of the power produced exceeds county needs, the letter should explain why that use is reasonably related to the essential government function. I came to the conclusion that it was essential government function and not the Dover Amendment. Contrary, I apologize to what I said last hearing. Mr. Lopez's response was, please be advised that 100% of the energy produced by the Canopy Solar Project will provide discounted energy to the Aggie School. This was October 16th, 2020. This is much different than what you're hearing from the North Street project. Thus, the decision that I made at that point proved to me that it was essential government function. So I'll say again, I don't believe, you know, I appreciate council's argument. I don't believe it's absolute. You know, you, the board, are tasked with making the local decision. You know, I hope you uphold my denial. But, you know, either way, I believe we're headed for another venue post Walpole, and we'll vet it out at that point as well. So I just wanted to make that point. If you have any questions, I'd be happy to answer them.
Anybody have anything for Mike?
Just one. Thinking about the bylaw, it talks about ground-mounted systems, and I was curious on your view of the canopy system. It strikes me that that's essentially a structure for the protection of the cars underneath, and whether you would consider the panels, or could the bylaw be interpreted as those were to be roof-mounted systems as opposed to ground-mounted?
Correct, and I'm not an attorney. I just
Yep.
pretend to be one by day till I need one. But, you know, we do try to interpret and utilize previous cases and utilize, you know, precedents in making decisions. And I think that's something why I just alluded to future cases related to this. This could go pretty far in interpretation of, okay, you're providing the roof as opposed to a roof existing already. Is that roof mounted or is it ground mounted solar? And then obviously the umbrella of central government function in Dover, and the protections under 40A Section 3 for for solar installations. So I think that could go pretty far. We've debated this previously. You know, is that a solar installation on a roof, or is it a ground mounted on a structure that was provided for the solar?
What purpose?
Again, I think we relied on the essential government function due to Mr. Attorney Lopez's response to my request for an opinion.
Thanks.
Do any of the current panels that are on the property tie back into the actual school electricity, or is it back fed to the grid?
So I believe we had a $1.8 million installation on the roofs of the school. I believe there are 3 or 4 buildings that currently have solar covering the roofs, and the roofs, we also had a 1 million dollar permit for roofing. We just had $1 million permit for upgrades interior of the school,
But does
along
it-
with a
does-
few more.
Sorry, does the electricity produced by the panels tie back into the public utility, or do they feed back into the school?
To the best of my knowledge and what we had discussed in the past, and based on this letter, it all goes back into the school.
The existing ones?
Correct, the ones that have been, all of
So
these.
the
have been
ones that are
installed.
proposed on North Street are tying back into the utility?
We just heard from council that 56% would go to the school and the county.
But the drawings that we were submitted don't show a line directed back to the school, right? I mean, it's back through the public utility,
So the roofs are what's called behind the meter.
right?
Parking lot canopy, the roofs were approved without even talking about essential government services. So the roofs, by definition, are a very different, structure than the parking lot canopy. The parking lot canopy, the building inspector asked us, how he could justify that, saying it was completely different from the roofs. The parking lot canopy is the same, same structure as the North Street array in terms of how the power will be used.
Okay.
That's clear, sorry.
Anybody else all set up here?
I just had one other question. I don't know if you would be the right person to answer this, but in the application for the site plan review, it talked about the town receiving property tax payments of a specific amount, and I'm just, I can see already that I shouldn't be asking you that question. But maybe I can ask the applicant that question, but anyway, I'll withdraw that, thanks.
I think we're all
All right,
set.
thank you.
Thank you. Proceed to
Yeah,
the
if I
second
could,
question. Is there anyone that could answer that question? I'm not-
Let me just get the,
I can answer that question.
okay.
Well, what's exactly the question?
So I'm sorry, trying to find the, so there was initially a site plan review application was submitted to the planning board. And in that, it provided information about the project. And one of the items was
Estimated property tax.
estimated property tax, correct?
So in our discussions, when we had a discussion and offered the opportunity for the town of Walpole to lease the land through, the, law that the attorneys can refer to much better than I, your town manager estimated what the property taxes would be, somewhere between $150,000 to $200,000 a year under Massachusetts law, based as personal property taxes. And that's where that number comes from. Roofs, and parking lot canopies aren't subject to that. Parking lot canopies are, ground mounted arrays are. That's where the number came from.
And currently, neither the county nor the school pays property taxes, is that right? To the
There's
town.
two different things you're talking about. You're talking about real property tax and personal property tax. The county nor the school, as far as I know, they may pay some pilot, but they don't pay real property taxes. Personal property is something very different.
Are you aware if the county pays personal property tax to the town?
I have
Okay.
no idea.
Okay.
I'm sorry.
Just, okay, thanks.
Let's open it up to the public. Is there everything else up for the public?
Yeah. It's fine.
You can always dig in later. I'm gonna open it up to the public. Come on up to the podium and name and address, please. Oh, we'll let him go first. Sorry, he didn't see you.
Thank you. I'm John Hassenjager, Precinct 1, Town Meeting Member. I'd like to ask a couple questions of the applicants. One being, how many solar panels in the other 20 cities and towns do you have in Norfolk County? How much solar are they contributing to your dire need?
I can answer. This is my knowledge, this is the county's first solar project. It is the beginning. It's only been working on it for 4 years, and we still haven't accomplished it, but we're continuing to work.
It'd be good to spread the responsibility out. The county should think about if it's gonna have a burden of solar. The other one, is this gonna be part of the SMART program? Just making a yes?
Yes, that's correct.
Okay, for the record, that's very important. The SMART program has layers of maps. The number one rejection for solar in Massachusetts is agricultural use. If the property has any agricultural use or shows up as important agricultural resources, it's immediately denied for participation in the Renewable Energy SMART program. There's a number of other criteria and at least a half a dozen maps. By definition, I was shocked to see this because many farms in rural areas, it's a very light footprint of agriculture, have been rejected for commercial grade or for this scale of solar arrays. So that's something you should definitely be looking into. The other thing that really concerns me is that the comments. I've been a town official for 50 years in Walpole. So we've worked on the zoning forever. The town has responded 100%. All this, everybody that applies for everything today, they're doing God's work for carbon footprints and green deals and so forth. Everyone's got an environmental stick about what they're doing. And Mrs. Coffey, I agree with you. I think you're being bullied in some of those statements. But this use of we have been very responsive in Walpole to renewable energy. For the last 5 or 6 town meetings, we have our zoning, our overlay in place. The town is meeting its requirements. We don't need any lawyer from out of town telling us what we have to do, that we're not meeting his requirements for green energy or for any other environmental standard. That's baloney. And I would submit the people he represents need to spread their interest and impact of renewable energy across all 20 of the communities in Norfolk County. The other thing that disturbs me is, this is a trend, folks, that really goes beyond the zoning board, but the residential use, the rural use versus the business use, that's why we did the zoning overlays. You can do solar. You have to buy property in the right zone and apply for an overlay. Not in an agricultural zone, not in a residential zone. We have worked on different proposals. We have, I think it's 4 solar projects now in town, and we have others on the books. But the fact that government is getting into businesses, they could be putting a supermarket up there or a drug selling operation. It's no different. What they're doing is putting a business on so-called school land in Walpole. And putting a business on school land is not in our zoning. In fact, what intrigues me is we changed our zoning so that all schools and education and government uses have a PSRO zone. And for some reason, this government school and government enterprise does not have that zoning, is not colored that way in the zoning map, which it should have been and should be. And that's the way it was defined in the language, but whoever did the map apparently didn't put the colors where they're supposed to be. But they should be. The Norfolk Agricultural School should be in the PSRO zone. And you can't put a business there, period. Any kind of business. Doesn't matter where it's green, blue, whatever color they're talking about with their baloney about environment and so forth. You can't put the business there. So, and that I don't like government getting into business in the first place. The government is supposed to be competing with private sector people. There are a lot of private people who put solar in Walpole in the right zones with, there are all over overlay district with their zoning regulations. So I'm definitely opposed to this on many levels, but those are my main comments.
Thank you.
Hi, Rudy Barajas, 1400 North Street. I'm speaking both individually and as a representative of the Walpole Preservation Alliance. I refer the board to the letter from WPA's attorney McGregor and Laguerre to the zoning board dated August 2nd, 2021, in support of the building commissioner's denial of the building permit. We would like to stress the following points. Walpole's building commissioner properly denied the building permit as the project is not allowed under Walpole's zoning bylaws. The reference letter from our attorney provides factual and legal support for the building commissioner's decision to deny the permit and for the zoning board to uphold that decision and reject Kearsarge's appeal. Our attorney offers counter-arguments to the arguments presented by Kearsarge at the July 2021 zoning board meeting, and again this evening, with legal basis and citing references to case law, unlike the most recent submittal from Kearsarge, and that is in reference to the August 6th letter that this board received from Pierce Atwood. The Dover Amendment and essential government function do not apply to the proposed project for the reasons stated in the building commissioner's well-reasoned and thoughtful denial and our attorney's August 2nd letter. The zoning board should vote to uphold the building commissioner's decision and deny the building permit. Thank you on behalf of the Walpole Preservation Alliance.
Thank you.
Suzanne, can I just? I've spoken to, as you know, but do you have that Legere letter?
No, I didn't have it either. August 2nd?
No, I don't think so.
No, I didn't have it either.
Maybe in here? You want this?
No, it's not here, I don't think. Can you come back? I'm sorry, can you come back?
Yeah, I only have,
Can that commenter come back? Thanks.
yeah, it's coming.
Was that letter submitted?
Have you seen it?
I will,
Here?
August 6, 2021, Mr. John Lee, Chair, Walpole Zoning Board of Appeals, and it is from Pierce Atwood.
Oh,
We
I
have
thought
that
you.
one, the first
They
one.
have, so they have that letter, and they have a letter received today from Norfolk County Agricultural High School. The Luke Legere, did he write a letter and submit it, or are you just saying he responded to it?
I'm referring to an August 2nd letter that Luke Laguerre submitted.
All right, did this,
It was via email.
Second.
Is it public comment?
do you have that?
I
It's
do have,
public comment, then it's in the public comment. Do you have public signature?
August 2nd, right?
I just wanted to make sure, because if it's on the
I'm
record.
just gonna
it
give
won't-
this to Amy another look. I don't see it in there.
While I do this.
Mr. Hamilton, you can speak while Bob looks if you'd like. What's his name?
It's from the public.
it was, yeah, sent August 2nd, 2021, 1:44 PM. A. Messier at Walpole,
Yeah,
mass.gov.
everything in here.
So that's Monday.
And it was CC'd to a number of other individuals, including Paul Feeney, Valentino Capobianco, Paul McMurtry, Jody Lanza, Daniel Bailey, and Scott Lopez.
Do you want him to email you a copy right now?
I can email a copy right now. I
If
can
she
get
has
my
it.
email.
Oh, she has it, oh,
Oh, at least to me.
I didn't have it.
And
I mean,
again,
I'm not a board member, I just want to make sure your record is complete. If it,
yeah, and again, that letter provided legal basis and reference to specific case law, which would be important.
I don't see it here, so
you do or
I
don't.
didn't see it in
No.
this one.
You might want to just send it again to forward it to Amy now, before the record closes.
Thank you. Come on up, Mr. Hamilton.
Hamilton, Precinct 5. There's a very important point that we need to make tonight and have happen. When petroleum leaked and wiped out the whole water supply for Apple Tree Lane, we could not go for negligence because the petroleum company never admitted that their gas station would not harm our water supply. Today, all petroleum stations have to put their tanks in protective casings, so they know that they can harm our water supply. But they have not stated during these meetings that this project that they are proposing with hazardous material will not harm our water supply, even though it is in Area 4, and Area 4 is a supplier of water to Areas 2 and 3. So I would like to have it on the record, however town council deems it necessary, that they are aware that this project is a threat to our water supply, and they will ensure that it will not happen. Because when it happened to Apple Tree Lane, Norfolk County charged me with 3 felonies. Felony trespass, felony vandalism of county property, and felony vandalism. And I had to appear in Superior Court with 2 other selectmen because we wrote an illegal order under duress, like Ms. Coffey said. We were bullied into it because the petroleum company would not bring water to Apple Tree Lane on the streets. They insisted on going through Norfolk County.
Yeah, I have
So
it.
we
I have it.
signed the order, we violated the law, and I was charged. Luckily, I was found not guilty. However, it's very important tonight, because they've already stated, and I believe will happen, that they'll go on to another venue, because I hope that you make the right decision tonight. So somehow, and I hope the town council can help me get some illicit from Kearsarge and the county, that they understand that this project could harm our water supply. Because then if it does, they are negligent, and we can sue immediately and not have to wait like we did in Apple Tree Lane.
Okay. Thank you.
Thank you.
Anybody else want to speak tonight? Anybody else set? Anybody else up here have any other questions?
Should we, before we vote
Should
to close,
review
should we
that
review
email?
that letter?
What's that?
If there's no other questions, should we review that email?
No, that's okay. Amy said it was in the packet, but he re-forwarded it tonight, so you have it in your record.
Okay.
Yeah.
All right, so everyone is all set in the public tonight? Do you have anything else you'd like to submit? Mr. Bailey?
Wait on your head.
No, we're all
Set?
set, thank you.
Mike, you all set? George? Anything you'd like to say?
No, not unless you have, no, not unless you have a question for me.
No.
I mean, I don't comment. I'm not
Well,
a board
I
member.
would need you to help me word a motion,
Sure.
please. So are you all set to close? Okay, make a motion to close? Could I
I
have
think
a
he,
motion?
there's one more
Wait a minute,
comment.
somebody
Oh,
down there.
time out. Come on up, sorry. I didn't see your hand, I'm sorry.
I would just like to say that if this board has not seen the letter from Attorney Laguerre, I would certainly hope that without that information, that it would not be prepared to vote. Thank you.
Did you just send it to us?
Why don't you just see if,
Can we take a break?
you can take that on his
Yeah. I think what we'll do is we'll take a 10-minute break for us to read that, article, if that's okay with everyone? Okay, can you forward it to all of us, Amy, please? Because I didn't.
Yeah, it's one,
I
just
would like
one
to
part,
read
I mean, you don't have to, it's in the record. I mean, if, you can see how the conversation goes too, but
Yeah.
if you wanna wait to
You guys have
Doesn't
it.
take
hurt
a
to take 5,
10-minute recess,
Yeah, yeah. I don't have to do a vote on that, we can just take a 10-minute recess, right?
right,
All right.
return in 10 minutes.
Let's just return at, we'll return at 8:15. We can read it by then.
There's 5 corners in that building.
Cliff, did you want to say something?
I was just coming up to say
To say hi?
haven't seen her in a while.
Oh, me, yeah.
Okay, I think we've about wrapped it up. I don't know if anyone has thought of any other questions after reading that email? Everyone's all set?
Mhm.
And I haven't made a motion, so I will make a motion, or I will, what if I ask for the motion to close the hearing?
Okay, I'd like to make a motion to close the hearing.
Second?
So moved? Second,
So moved, second.
or out of order, sorry. And any discussion? All those in favor?
Aye.
I think it's closed. And now I need help with the wording, please, if you want to make the motion yourself, if you can.
Well, did the board member want to deliberate and discuss at all?
Anybody need to deliberate? It's not,
I guess I'd just like to lay out some thoughts, if that's all right.
feel free.
So I think, not to speak for everybody on the board, but I personally, and I think everybody on the board is in favor of attacking climate change and the challenges that that poses. But as the board, we're sitting here to evaluate whether the appeal of the building commissioner's decision was appropriate. And there were the 3 issues that we were presented. One was the essential government function piece. The second was the educational purpose, and the third was with regard to the application of our solar bylaw to the project. And I guess in my view, raising revenue as broadly considered and construed by the county is certainly something that the county can do, but that doesn't mean, in my view, that they can raise revenue in any way that they want to. And by leasing lands to a private party for purposes of generating power, something that the county has never done before, and so it strikes me as not that essential if it hasn't been done in the past in terms of providing a essential government service at the county level. And I think it is fairly well established that if a private party is making use of public land for private purposes, that activity is subject to zoning. So I don't think that they've carried the day on the essential government function piece. With regard to the educational purpose, as I think there's general agreement that the case law says that the educational component must be a predominant purpose for which the structures in the land are used. And I think we heard testimony tonight and in the papers that the predominant purpose of this, in my view, is to raise revenue for the county. The fact that there's an element of the RFQ that deals with preparing a 9th through 12th grade curriculum certainly is a component, but I don't think it's the predominant purpose. And I think we heard that climate change and revenue raising and those things were really what was driving this particular piece. And I also, while there's a roster of existing classes that might serve as a platform for some curriculum, it doesn't strike me that a comprehensive curriculum has either been prepared. Even if the contract was signed in January, it read to me that within 4 months of that time they should have had a full-blown curriculum on this. So it just speaks to me that the level of the purpose and the urgency of the educational piece certainly isn't of a piece with the economic benefits. And then with regard to our solar bylaw, the bylaw does not, you have to look, I think, at the bylaw as a whole. The application that prohibits a particular use is obviously going to lead to an argument that it wasn't fairly applied to that particular use. But as a whole, the bylaw doesn't prohibit the installation of solar energy systems. Rooftop solar is not prohibited or regulated really at all, and the regulation of ground-mounted solar energy systems applies only for larger systems that are 1/4 of a megawatt or more. And I think it's reasonable for the town to determine where these larger systems can be located, particularly to protect open space that's used by the community as a recreational resource and with trails and the like, as a provision of the public welfare, and to protect the rural residential district, which explicitly deals with, rural settings, agriculture, open space. It's just not the place, as reasonably determined by our town meeting, that there's certain areas where those can be permitted and certain areas where they won't be. But that doesn't mean that the town is prohibiting solar everywhere. So I think on whole, the bylaw is reasonable in my view. So for those reasons that I offer the board, I think, I'm inclined to deny the appeal based on the grounds that they've set out.
To uphold the building inspector.
Yes.
Another way of saying it. So I just offer that as.
I appreciate that.
Thank you, appreciate that. Well,
Okay. Anybody want to comment on that? Thank you, appreciate it. All right, so let's take a vote.
you have to have a motion, though, yeah.
Okay, so, you can.
Well, you need a motion before you
We
can
do
take a
need a
vote.
motion.
Yeah.
Okay, so the, correct me if I'm wrong, but
Sure.
my understanding is it requires a supermajority vote in favor of the appeal to overturn the decision of the building commissioner. So I would make a motion the motion would be whether the board should grant the appeal of the applicant to overturn the decision of the building inspector. So an affirmative vote would be to uphold the appeal, and a negative vote would be to deny the appeal and uphold
Negative upholds building
the
inspector.
building inspector, correct.
Everybody understand?
You could also present, I just want to clarify, again, good evening, I'm George Pucci from Town Council's office. And I'm here to, usually I speak when spoken to, but just to give you a little bit of guidance on the vote.
Yes.
So you do need a supermajority to overturn the decision of the building commissioner. So it would be 4 out of 5 to do that, and that would be upholding the appeal and overturning the order. Another way you could do the motion, it's entirely up to you how you do the motion. You could also have a motion to deny the appeal and uphold the decision of the building commissioner and see how the vote goes on that. Or you could present it, move to affirm the appeal and overturn the building commissioner. So you could do the motion in either of those ways. I know that we had, in the last few months, we had one that you got a little bit confused.
Yeah.
Probably because of poor guidance from town council, I'm sure.
No.
Doesn't take much.
But the vote came out okay, but it took a couple of tries.
Right.
But you could do it either way, so whatever you find easier. But you don't want to have a situation where you're confused.
Where you don't.
Yeah.
All right, what does this mean? What am I voting for?
That's why I would rather use the word uphold.
So you could actually have a motion to deny the appeal and uphold the determination of the building
That's pretty
commissioner
clear.
and vote on that.
I like that one, it's pretty clear.
Is that one clear?
Yeah.
Okay.
So should I make? Sure. Okay, I'd like to make a motion to deny the appeal and uphold the decision of the building commissioner in this matter.
Second?
So moved. Seconded by
Second,
Jane.
right.
Any further discussion? All those in favor?
We have to,
Aye. Unanimous.
you have to go for it.
And just to clarify,
Full
so
roll
you'll need to file a written decision within 14 days of the town clerk. You know, if you don't have a meeting between now and then, you could authorize, the decision to be signed by the vice chair, if he's done that
I
before.
will make a motion to have Bob sign.
Yes.
Hold on a second. Oh,
One
you gotta
second,
hold
we're in the
on.
middle of a vote. It was unanimous.
Thank you.
Second,
Second.
to have Bob sign. All those in
Okay.
favor?
Aye.
Sorry, we were right in the middle of it, I apologize.
And that
So that
needs-
was unanimous, 5-0 to uphold the building inspector.
So,
Hold on. So just make sure 14 days, you're gonna get that.
Yeah.
I'll look at it, obviously. You'll sign it, and then you'll file with the town clerk.
So I think we're good.
Done with me?
Yeah. And do we have minutes?
no,
No minutes?
no.
Amy, I want to.
Motion to adjourn?
No, I want to make this, I have something I'd like to
Jane wants
say.
to make a speech.
First of all, I want to take a minute to recognize Suzanne, whose last zoning board meeting is this evening. She's moving to her summer home in Falmouth. Suzanne is a true Walpoleite, having urged. Suzanne is a true Walpoleite, having lived here since birth, and as soon as she became of age to participate in town affairs, she followed in her father's footsteps, Jake Murphy. She became an RTM member for years and years. In the years that followed, she served the town in many capacities. In addition to her many years as an RTM, Suzanne has served terms on the planning board, zoning board, recreation, and for a long time working with the elderly at the senior center. She has made a tremendous contribution to her beloved town. Her knowledge of the town and her deep commitment to the town has made Walpole a better place because of her efforts. Not to mention she's bright and she has an Irish wit and a great sense of humor. Suzanne's departure from Walpole. Suzanne, I know I speak for members of the board in wishing you well and happiness in you and your husband's retirement. To say you will be missed sounds trite, but those feelings are truly most sincere. This is not a goodbye, Suzanne, and I'm sure you will stay in touch with your many, many friends and contacts. We wish you peace.
Thank you. Thank you all. This is the best town in the world.
Yeah.
I know I'm leaving, but it still is the best town in the world. No getting around it.
Amy, make sure that's in the minutes for you.
Well, thank you all. I appreciate that. Makes it well worth it.
Yep.
Been doing this a long time.
It's okay, George, yeah, I always have the work left over.
Yeah, really. Thank you all. Thank you.
Good luck.
Thanks.
I know we always didn't see eye to eye, but I
That's all right.
appreciate your passion
That's
for the town.
Thank you.
Did we adjourn?
Thank you.
Nice.
Thank you. He would. Yes.
I'd like to make a motion to adjourn.
St. Mary's in.
Thank you, Mr. Crowley. Feel fine for you. Okay. When I get home. Thanks, Billy. Thank you. Good to see you. Thanks. Keep it all going. He's going good.
Himself so
Him and
bad,
Dad.
they had to get the.
Really? Yeah, just
fire
did.
department there, and then his wife-